We have it. It is here. I think we may have found our so-called assault weapons case that will be going to the United States Supreme Court. We're talking about the future constitutionality of laws that prohibit ownership, possession, receiving, transporting, yada, 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 AR-15s, AK-47s, Steyr AUGs, on and on and on. Maybe for you like hipsters out there, FN2000s, whatever. This is probably going to be the case that will go to the United States Supreme Court to determine our future there. What are we talking about? We're talking about the Maryland Firearms Safety Act of 2013. The Fourth Circuit Court of Appeals just had a massive decision on it. We are teed up for the United States Supreme Court, and the Firearms Policy Coalition and the Second Amendment Foundation are more than happy to take the charge there. Guys, let's get into it. Our AR-15s, AK-47s, and of course those ever pesky Barrett 50 caliber rifles that we know just litter crime scenes across the country, are those protected by the Second Amendment or are they not? That was what is being decided when we're talking about the Maryland Firearms Safety Act of 2013. For a full list of all the different weapons that are banned, long story short, it's all the usual suspects with all the usual reasons. Check it out in the description box below. Just know that if you do decide to possess them in Maryland, you are looking at a felony and up to 3 years in prison per firearm. So we've got this case. It's coming out of the Fourth Circuit Court of Appeals. Remember that there's 94 federal district courts. These are the trial courts. You get arrested, charged with a federal crime. You start at the federal district court. From there, you appeal to one of the 13 circuit courts of appeals. We're in the fourth one. For those of you in some challenge states, that's the number between 3 and 5. Maryland, North and South Carolina, Virginia, and West Virginia. That is the Fourth Circuit Court of Appeals. And what they did is they did something very unusual here. They did a little bit of an okey doke because typically there's a group of judges in each one of these circuits. It could be 8, 20, it varies depending upon the size. And then when a case gets appealed to them and they accept it, there will be a random selection of perhaps 3 judges that will hear that case. Sometimes if those 3 judges reach maybe a decision that one of the parties does not agree with, those parties may petition that the entire circuit, in other words, all the judges, hear the case en banc. That's a very fancy legal way of saying everyone, okay? Usually that only happens, the rare times that it does happen, following a 3-judge decision. That is not what happened here. Here, it's going to a 3-judge decision, and then all of a sudden, the Fourth Circuit steps in and says, we're doing it en banc. Does that mean that they did not like the decision that was going to be getting reached? I think so. But just understand that we had some very odd things happen on the way to Damascus. So their decision is kind of legal light because they're going to take what's probably the shortest path to disarming civilians and banning firearms. Bad news, that's awful. Good news, it's reasonably easy to talk about. What they're going to do, and they're going to set this up, linked in the description box below is the case if you want to follow along. But starting on page 51, they start going into what are the differences between the military M16, you know, the full automatic rifle, versus the civilian AR-15, that's the semi-automatic only version. And they start talking about firing rates and they start talking about features, and they basically say, look, you know, these are much more alike than they are dissimilar. They start going and quoting the U.S. Army Field Manual that instructs people, and you can read this. This is all in the decision. I'll quote part of it here. The U.S. Army Field Manual instructs that semi-automatic fire is, quote, the most important firing technique during fast-moving modern combat, end quote, because it's the most accurate technique of placing a large volume of fire on multiple or moving targets. So basically what they're setting up is they're saying, look, M16s might be full automatic, and that might be the military weapon. However, even the Army says, yeah, you may not want to use these in full automatic much, if not perhaps even all the time. You want to be using semi-automatic. And then, get this. They quote from the decision, same page, a decorated former U.S. Navy SEAL from the decision. Indeed, a decorated former U.S. Navy SEAL stated that he, quote, never once fired full automatic in combat, end quote, during a decade of special operations, combat deployments, including the 2011 Osama bin Laden raid. So what is the court saying here in English? They're saying, look, M16s may have the capability for automatic fire, but really, they're most lethal and they're most dangerous and they're most often used in semi-automatic, just like the AR-15. So the court's basically equivocating and they're saying, look, same. That's what they're saying. They are trying to reclassify upstroke an AR-15 into being a so-called military-grade firearm. But yeah, they're not capable of full automatic weapons fire, but then the court goes on to say this, quote, moreover, the AR-15's rate of fire can be easily converted to mimic military-grade machine guns with devices like bump stocks, trigger cranks, and binary triggers. And then the court goes on to page 32 to say that between its firepower, accuracy, and modifiability, the net effect of the AR-15's military combat features is a capability for lethality. All this is a far cry from any notion of civilian self-defense. All of this is a far cry from any notion of civilian self-defense. So they're basically saying an AR-15 is the net effect equal to a military-grade M16, and that as a result, no civilian needs this. To back up this point, they basically go into looking at shooting statistics that show, in essence, again, low resolution, that mass shootings and when bad guys do bad things, when they use AR-15s, modern sporting rifles, they are capable of creating more death than if you just use, say, a regular handgun or something like that. So a normal Glock. Be sure to stick around to the end. I've got a fun quote of the day coming up at the end. Let me know in the comment field below where you think this is going. What do you think the outcome is going to be? Why did the en banc come in and usurp the case from the 3 judges? Do you think that it was because the 3 judges were going to rule in favor of the Second Amendment? Do you think 10 years from now, AR-15s are going to be constitutionally protected, or are we just going to go the entire negative route? Don't forget to hit that like button. Now back to the video. But why are they all saying this? What's the end game? So the end game is this. And if you want to see me do a deep dive video on this, let me know. I'm more than happy to do it. I've been working on one for quite some time. The end game is dealing with the concept of whether or not a firearm or a weapon is dangerous and unusual, or as the court calls it here, excessively dangerous. Why? A lot of anti-gun people have been arguing for the fact that found within the lineage of American and before that British jurisprudence and case law, so our body of shared legal traditions, that there's always been, in essence, a loophole for the fact that people do not have a right to possess unusual and dangerous weapons. The Supreme Court has talked about this a little bit. We've seen other courts talk about it more. This is it. This is going to be the face of this argument to determine what is and what is not a dangerous and unusual weapon. Now, this is not me advocating, this is me predicting. I do think that the NFA, at least as it relates to full automatic machine guns, I do think that the Supreme Court is going to decide that that is a dangerous, unusual weapon. I'm only the messenger there. I'm 0% advocating for that. I'm not editorializing. I'm just predicting when I say that. The question is, can they now expand that, the gun grabbers, to include all modern sporting rifles? But I also want to just highlight for you one of the arguments that they're making here. On page 32, what I just covered is they're talking about the fact of binary triggers, trigger cranks, and basically semi-automatic weapons that can be upstroked in capability to becoming automatic weapons, as now simulating and mimicking and therefore being somehow equivalent to a military-grade weapon. Where have we heard recently this argument and where it could go? Anybody heard with me the fact that, oh, Glock switches can convert a Glock into a full automatic weapon, even though that's a felony in every sense of the term? Now that means we must be able to ban Glocks because they can somehow be converted. You can see how one domino sets up the next and so on. I also want to share something else that this reminds me of. The 2020 Insurance Institute for Highway Safety. Yes, we're talking about the IIHS. 2020 released a study talking about basically how incredibly lethal, according to their study, pickup trucks and SUVs are in different collisions, and particularly when we're talking about vehicles versus pedestrians. Reading from their study, whatever their nose shape, pickups, SUVs, and vans with a hood height greater than 40 inches are about 45% more likely to cause fatalities and pedestrian crashes than cars and other vehicles with a hood height of 30 inches or less, and a sloping profile. An IIHS study of nearly 18,000 pedestrian crashes found. However, among vehicles with hood heights between 30 and 40 inches, so under 40 inches, a blunt or more vertical front end increases the risk of pedestrians as well. Pedestrian crash deaths have risen 80%. Since hitting their low in 2009, nearly 7,400 pedestrians, that's more than 20 per day, lost their lives in 2021 after being struck by a vehicle. Why am I talking about this? Because if the courts are going to start making arguments about the fact that we can lose our rights because, hey, something correlates to a more negative outcome, can you see where that language and where that reasoning, effectively, it's just utilitarianism, okay? Where that goes to. And by the way, when I say where it goes to, let's talk about where it should start, because we don't have, and I'm not suggesting we should ban our SUVs and pickup trucks, to be clear. However, if we're going to start doing things based on a utilitarian approach of what's going to save lives, we lost 7,400 people, walkers, joggers, so forth, to vehicle collisions. And we know that these vicious assault vehicles, pickup trucks, SUVs, are way more lethal than your regular car or something like that. Also, I'll just add, do you realize how many more people die from these sorts of collisions than AR-15s? AR-15s are mind-bogglingly safe. When we're talking about the fact we've got about 24 million, according to another court, about 24 million AR-15s and firearms like them. Yet each year they account for less homicides compared to people who died due to lawnmowers, bees, ladders, deer, constipation, people falling out of bed. Backyard swimming pools alone kill somewhere between 6 to 12 times more people each year than AR-15s. And now we've got SUVs and pickup trucks potentially causing almost 100 times the death compared to AR-15s. But this court wants to start with them. And of course, all this is ignoring the fact that diabetes kills about 80,000 Americans per year. Chronic lower respiratory diseases kill about 154,000 Americans per year. And heart disease kills 635,000. Yet when I go to a grocery store, I can still buy those assault packs of salt out there, or the 2-liter assault varieties for Coca-Cola, Pepsi, you name it. And all that kind of stuff is legal. So I think it's really interesting that courts want to take a utilitarian approach here on something that is protected by right and by common law and by, of course, the United States legal and American tradition going back to before the founding of the United States, while leaving all these other things alone. Does that sound a little convenient to you? Let me know in the comment field below. Where is this all going? I'm sure the Firearms Policy Coalition will be appealing it immediately to the United States Supreme Court. We'll be seeing where it goes from there. Guys, join FPC, join SAF, join GOA, and join National Association for Gun Rights. All these organizations are amazing organizations who are out there doing the lifting and lead blocking for you, for me, for all of us and our kids. Be sure to support them. Membership is quick, easy. I'll try to get some links down in the description box below. So ultimately, the court ends where we know that they're going to end. And they say this, quote, "We hold that the covered firearms are not within the scope of the constitutional right to keep and bear arms for self-defense." Notice the for self-defense. See how they keep adding this? 10 years ago, it was all sporting test. Now it's the self-defense test. The court goes on. And thus, Maryland's regulation of them can peaceably coexist with the Second Amendment. Moreover, even if the text of the Second Amendment were read to encompass the covered firearms, the statutory provisions at issue would nonetheless be constitutional. Our nation has a strong tradition of regulating excessively dangerous weapons once it becomes clear that they are exacting an inordinate toll on public safety and societal well-being. Just like backyard swimming pools, just like lawnmowers, just like, large tubs of salt and everything else, right? Because that kills way more people. So don't tell me that this is what it's about, because if it was, we would be starting someplace else. And our quote of the day, quote, "You cannot discuss the ocean with a well frog. He's limited by the space he lives in. You cannot discuss ice with a summer insect. He's bound to a single season." This one comes from Chinese thinker-philosopher Zhuangzi. Can you discuss principles of liberty and freedom when we're talking to perhaps certain members of the government, certain members of law enforcement? Is this a fair quote? What do you guys think? As always, I appreciate you sticking around, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.